Morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access on our civil docket, both in the courtroom and also online. And we have a couple motions up in Lang v. Homeowners. It's file 25-9120CK. Counsel, you want to state your appearances, please, beginning with plaintiff?
Good morning, Your Honor. Raymond Spaloom on behalf of plaintiffs.
Good morning, everyone. I'm John Friel on behalf of the defendant.
All right, good morning. We were on for a pretrial. I did receive the waiver form and signed that and have entered a scheduling order that should be going out to all of you. And I do see that there's a motion for summary disposition that's been noticed up for next month. Today, we've got plaintiff has a motion to compel and for leave to file more than 20 interrogatories, and defendant has a motion to compel and for a protective order. So counsel, is it okay if we argue those together and I just have plaintiff go first, then defendant?
Absolutely.
Yes,
Okay.
Your Honor, that makes sense.
Mr. Saloon, go ahead and state or argue your position on both motions then as you see fit.
Okay, thank you, Your Honor. The crux of our motion for additional interrogatories really centers around what were titled affirmative matters, and there were like 30 of them. So I think we need at least one interrogatory for each affirmative matter or affirmative defense, but they're called affirmative matters. But this is since having filed this motion, defense counsel did send to me what appears to be the claims file. It's a huge document, literally over 1,000 pages, but I can't tell. There's no way to tell from that, even from the checks that are written, what part of the claims were paid. And I think what remains open is $200,000 for contents and up to $60,000 for code improvements or code enhancements. And even if we went through every individual check, it doesn't say what it's being paid for. It doesn't give us the how they determine the ACV. So even the percentage of the claim under the policy, we can't tell. That's why we need the data that was used by homeowners to determine, from their point of view, the claims that were presented and what was paid on the claim and what remains open.
And it seems that Mr. Friel's client's position is that they don't need to do that work for you. Here's the file and you figure it out. Is that sort of how you understand their position to be?
Yeah, their position is here's 2,000 pages, go figure it out. But even if going page by page, we would not be able to determine without their data how they determined, for example, the ACV, you know, how did they discount it I mean, it shows that only $5,000 of the recoverable depreciation was actually paid on the few checks that we can actually determine. How did they determine that only $5,000 of recoverable depreciation should be paid? And here's something else very interesting. So my clients, this claim went on for a year and a half. My clients were representing themselves and handling it themselves. And about a year ago, they retained a public adjuster. And once they obtained the public adjuster, Mr. Orr, another $550,000 was paid. But I'm sorry, $200,000 was paid. But we couldn't tell from that what part was for the, you know, how they determine, as I said, the actual cash value, and what, if anything, was paid for the guns. There were guns stored in the basement, and they had to be turned over to ATF, and you know, for disposal. Some of the checks may be for part of the guns, but we can't tell again without their data. That's why we need to know, and they would have that readily available. You know, this check was paid for this claim. This claim was depreciated X amount of dollars, and that's why this check equals this. And that's really it. Our interrogatories, in order to prepare the case for trial, we need answers to that and to see the balance of the claim, and hopefully maybe work out a resolution of what's left on the claim.
Well, where would they have that data if it were not in the claims file?
Well, we maybe it's in there, but they can point it out to us. We can't find it because some of the checks don't say what they were paid for. It was just with the cover letter.
Okay. And your response to their motion to compel and for protective order against further discovery, saying that you haven't answered their questions about your claimed damages?
It's actually kind of a round robin. That's why we need that information. We did state that in our answers to the interrogatories. In order to calculate the balance of the claim that we believed left, we need that information. You know, what was paid, what remains unpaid.
Okay, thank you.
Yes, Your Honor. Thank you.
Mr. Friel, what's your position on these motions?
Thank you, Your Honor. It's not a round robin or a chicken and an egg. The way it works in litigation is the plaintiff states their claim and we respond. To the extent that they haven't indicated, we feel we've overpaid this claim. It's almost $1.8 million. There is no code upgrade coverage, for example. If that were specifically stated in the complaint, then we could specifically respond to that. What I have done is, and I think I've included it in my motion response, I don't agree with the characterization of how we've presented the information. Our response to interrogatory 6 goes on for almost 3 pages, single lined, breaking down by category, by coverage part and subcategory of coverage, every single payment that was made, getting to nearly $1.8 million. You have to take the policy and look at it, and then you have to look at the payment, and you have to factor in things like policy limits or what coverage they actually purchased. So this is kind of like buying a car. You don't buy directly from Ford or General Motors. You go to a dealership, you order a car. A few weeks later, if they have to, at least when I was a kid, they used to actually then make it, and you'd go pick it up at the dealership. But either way, there's a retail relationship. They did the same thing with their insurance with their agent. We issued the coverage that they purchased. And it's kind of like going back to the dealership and say, I don't want a car anymore. Now I want a truck. You can't say that after the fact. They decided that they sued. I think we're being as fair as possible with our interrogatories. What amount are you suing us for and why? And they're single sentences. And they say, well, we can't tell you until you tell us what your affirmative defenses mean. I might have to even change our affirmative defenses once they, like, for example, if they had pled in there, you're in breach of contract because you owe an obligation to pay code upgrade and you didn't. We would answer that by, no, we did not pay it. And as was explained in writing previously, and it's evidenced by the file, but it was also mailed to these folks. None of the file contents are a secret. You don't have code upgrade. That's a different kind of defense than, well, you didn't pay your premium on time, or you're not the named insured. You're doing business as a partnership that's not listed. We're not asserting any of those technicalities. It's pretty simple in this context. We think we've overpaid. If we get into interrogatories that are open-ended, it's going to be follow-ups and then follow-ups and follow-ups. There's such a thing as a deposition. If they want to depose, the adjuster who made these determinations, they're free to ask to do so. But I think that it's omissive to not mention our response to interrogatory 6. We basically answer all their questions at once. And like I say, 3 pages is a single space. There hasn't been any interest in asking me about, what do these categories mean? Well, they correlate directly to the policy. So other than that, I think I've set forth our position in terms of our motion. It's simple. It's like, let's get some guidance from the court. Let's get this straightened around. And if taking their deposition, would be a better way to get to the things that I'm now this morning hearing for the first time, we'll be happy to provide an explanation as to why that hasn't been paid for, as well as why we've overpaid some things. But I also want to state one thing just further for the record, and then I'll be done. The dispositive motion doesn't have anything to do with this. It has to do with the fact that the suit wasn't commenced within the 2-year, that's the 2-year period of limitations provided in the contract. So answers to these questions are kind of moot if that's a valid issue. And I'm not here to argue that motion today, and I'm sure plaintiff will have a response. And maybe I'm wrong on that, but it's not as if we can't proceed with effectively a statute of limitations argument while we quarrel about whether they do or do not have code upgrade.
Right. Well, can I ask you, so how is from your client's perspective, how is plaintiff supposed to cut through this Gordian knot of all these several individual payments of smaller amounts versus larger amounts, and look at all of this together in a complex claim and determine, what fell short, or whether the claim was fully paid?
Basically the same way I did when I answered interrogatory 6. That wasn't copied and pasted. I went through the file and we produced the file as it's maintained. Some people may be surprised that a Fortune 500 company just puts all the documents into a folder like that. But that's what I at least went through and straightened it out chronologically. You can only imagine what it's like when it's just the name of the file. But I had to go through that whole thing while I was preparing for a trial downstate and put that in chronological order to make it easier. I redacted attorney, communications. And then when we answered interrogatory 6, I assimilated that information with what the policy says. There's been no correlation of any fact. There's no facts alleged, and there's no correlation to the policy. That's how you determine whether or not somebody's up to snuff on a contract or not. So that my answer is he'd have to do the same thing I did. And I would say that's not anything to feel sorry about. They wanted to sue us. Tell us at least why. If he's right on something, we're likely to just pay it. We're not here to try to save $800 or $8,000 or any amount that we owe. It's just that they've already overpaid. They're not taking it personally. And if you go through the file and you go through the policy, you can draw your own conclusions. And I've laid it all out. If they disagree, like some of the things he was alluding to just now, let's have a conversation about that. But until then, it sounds like they want to, this could be an endless interrogatory mill.
All right, thank you. Mr. Saloom, your response?
We're asking, for example, the checks that were paid, we could get a line item as to what that refers to. There's $200,000 of contents. Some of those checks are mixing up contents and structure. We need to, and your client would have that information as to how to separate that. And then another issue, and this shows the important, the disconnect here. I believe counsel believes that there was no coverage for code upgrades, but the deck sheet does specifically say code upgrades up to $60,000.
All right, well, thank you. I've got two motions here. One, plaintiff's motion to compel and for leave to file more than 20 interrogatories. It says that the plaintiff argues that the defendant has failed to answer some of the interrogatories about which coverages were reflected by certain payments. The defense response is that it has complied as best it can. It's gone above and beyond by providing the entire non-privileged claims file and has laid out in detailed lists each payment made, the date it was made, to whom it was made, and some information, and also a breakdown as to which coverages it applies to. I think they have issued responses that are responsive to those interrogatories by the nature of their responses. So I'm going to deny the motion to compel. I think they have given a good faith answer. I'm going to deny the motion to file for leave to file more than 20 interrogatories without prejudice to refiling that motion, Mr. Saloom. How I would prefer to address that is if you think there's more interrogatories needed, I'd like to see them attached to the motion so that we can assess their scope and their propriety. And so if as you go through the file, there's an interrogatory, you want to ask a question and you'd rather do it by an interrogatory than a deposition and say, hey, this check on this date, what did it represent? How did you determine that amount? I think those may well be proper interrogatories. So I'm going to deny your motion to compel, deny the motion for leave to file more interrogatories without prejudice to you refiling it with proposed interrogatories attached. On the defense motion to compel and for protective order, I'm going to deny the motion for protective order. I don't think there's any grounds to bar the plaintiff from proceeding on discovery. And the defendant argues that, well, we're being sued and nobody's explained to us what we're being sued for, what we haven't paid that we were supposed to have been paid. And the plaintiff quite candidly admits they're trying to sort that out. And they do have a limitations period. And I understand we're gonna have some argument about whether they've already missed it, but they can't just wait forever. They have to file this suit. And then they're trying to sort this out sort of on the go. And I'm not unsympathetic to that situation the plaintiff's in. The defense does have a good point that they are entitled to know, however, what the claimed damages are. So I think I do have to grant the motion to compel those more specific answers. However, I'm going to give the plaintiff a longer period of time to prepare those responses, because then they may need to go through that file with some more fine-tooth comb. So I'm going to grant the motion to compel, but give plaintiff 60 days to file more detailed responses. And Mr. Saloom, you can also petition the court for an extension of that deadline if it's necessary. For example, if you renew your motion for more interrogatories, and I grant that, and you need that information to respond. So I'm open-minded to that as well. So bottom line is I'm denying plaintiff's motion to compel, granting defense motion to compel. Plaintiff has 60 days to respond, denying the defense motion for protective order, denying the plaintiff's motion for extra interrogatories without prejudice to its refiling. So I don't know, between the two of you, you can sort out if you want to put all this in one order that you can submit stipulated as the form, or whether you're both going to submit orders under your motions. Anything else that we can do today, Mr. Friel?
I think that's it. Thank you.
Anything else we can do today for you, Mr. Saloom?
No, thank you, Your Honor. Understand.
Okay, we'll see you guys next month.
Thank you.